second session of our training for the senior moot. As Sante said, and as many of you know, my name is Christopher Rawson. So I just wanted to show you my face quickly before I start the presentation today. All right. All right, before I can begin, everything looks all right on my side. Tell me, can you all see the presentation?
Yes.
Perfect, thank you. And thank you for the positive responses. Seems like you guys are going to be a little bit more interactive with us today. So today we are going to be looking at legal research specifically. As I said, my name is Christopher Rawson. I'm an attorney here at the Legal Affairs Law Clinic. This is part 2 of our senior moot training, dealing with legal research specifically. After this, you'll be dealing with general and legal writing specifically. And then we'll be looking at how to reference and draft memorials for the last 2 sessions. Right, so we're going to look at legal research specifically today. Just to give you a bit of an overview of the presentation I'm giving today, we are going to look at the step-by-step research process. I'm going to give you some guides on how to access and navigate the university's databases. I'm also going to give you a few tips and tricks and sheets that you can use to improve your legal research, or at least improve the efficiency or efficacy of your legal research. And I'm going to use a sort of hypothetical set of facts, just to, to explain as a practical level, to explain to you how, you start this process and how you continue this process for the next couple of months. Right, so legal drafting and research, legal drafting, there's always this quote that I put up just for entertainment's sake, but it's always a good thing to keep in mind that when you are going to use pro formas, you must just remember that the cases differ significantly, and the person who drafted the pro forma set it up with a very specific reason in mind. So when you are drafting these legal arguments, you need to remember that you always need to be clear, concise, logical, rational, and it needs to be a complete representation of your client's case. So this is an important starting point, because you need to keep this in the back of your mind while you are doing your research. You need to keep the facts in the back of your mind, and you need to keep your arguments sort of in the back of your mind as you start reading through all of the research. So there are specific steps we take in legal drafting. I don't know if you guys remember, but I did give this with this slide specifically in the previous session as well in the introduction. So your first step is to obviously get the facts, and then you look at all the issues and the points in dispute. Your third step, and this is the step we're dealing with today, is to research the law to contextualize the facts. Step 4, which would arguably follow today's session, but we're not going to give you a lesson on it because it's only you that can really comprehend and properly apply the law to the facts. And your step 5 is obviously to reach a conclusion. So we're going to be considering step 3 today, the legal research. I also want you to keep in mind, our director, Mr. Paul Antweni, always reminds me of this, and I think it's a good way to read a set of facts, but it's also a good way to do legal research. You always need to remember who are the parties, what are the legal rules that apply, what is the sequence of events, what are the dates, what are the locations, and how did everything come along. Because you'll find a lot of useful information when it comes to parties. For example, you need to know, are you dealing with an individual? Are you dealing with a company? Are you dealing with a government? For example, you also need to look at the legal rules. Are they private rules? Are they public law rules? You need to look at the dates and the locations, because that's obviously going to affect the jurisdiction and what you're going to study and where exactly you're going to look for sources. And you're always going to keep in mind how the specific events led to certain causes and what kind of legal sources you want to use to try and support your argument. That's just a general background. Before I move forward, are there any questions up to this point before we start discussing legal research specifically? So Shonda, can I confirm that you're recording the session? Okay, perfect. So then I'm just going to continue into the step-by-step legal process. All right. So what is legal research? What is legal research, and what is research in generally? So research consists of the process of finding relevant sources. Usually in law, they are primary and secondary sources, and ensuring that those sources are still valid and have not been repealed or criticized. Legal research is really a skill that you can learn, and the more you practice it, the quicker you become. So as soon as you become fast and effective in the way you undertake legal research, you'll realize that you save yourself a lot of time and energy and costs, and it improves the quality of your work. Especially for many of you who are one day going to be practicing attorneys, you understand that 50, 60, 70% of our job is really about finding legal research and undertaking legal research to give our clients good answers in law, and not to give bad advice. So the better you can become at this, the more time you can save, the happier your clients are going to be. And as you start saving your clients costs and giving them good advice, you're obviously going to improve your reputation. Many of you think, I always start this lesson and then I ask usually in person, I'll ask the class, has anyone ever undertaken legal research or any other research? And then people say to me, no, they've never done it. The whole class sort of sits there in silence. And then I wonder, but how true is that? Surely there are undergrad assignments and tests, and reading textbooks, for example, that is a form of legal research. You are looking for a specific chapter dealing in contracts, for example. So if you get a assignment question on the parole evidence rule, you're going to go look in the specific chapter in the contract textbook. And that is a form of legal research yourself, even if you're preparing for tests. You obviously, if any of you decide to continue studying one day, you continue to do your master's, your PhD, maybe even go into academia generally, you are going to do legal research every single day, right? That is how you build either your mini dissertation. I think you guys are going to do a mini dissertation. Some of you are probably already doing a mini dissertation now. But even if you're going to do your dissertation and your thesis the year after, you're going to undertake legal research. Obviously, as if you're going to take part in moot courts, you need to do legal research. And if you start practicing as an attorney one day, or even as a financial advisor, you are going to start undertaking legal research as well. You are going to get clients, you're going to get disputes, or you're just going to, your boss, if you're working for FMB, for example, is going to come to you and ask your opinion, or ask you to draft an opinion on a specific thing. And this is where you'll have to start undertaking legal research as well. Then, I undertake legal research, or I undertake research whenever I prepare these presentations. So it's just a way to ensure that you're always up to date, and it reminds you of what you need to speak about in these kind of fields. So the point I want to make here is, as you do more research on similar topics, right? So as you get more clients that have issues with contracts, or if you take part in moot courts that deal with any international body like the International Court of Justice, the more you research those specific topics, the better you get at it. And this really improves you. It ingrains the information in your mind first and foremost. But it also, the quicker you can do it, the better you can make these presentations. And the more presentations or cases or assignments and tests you can do at the end of every single day. And lastly, in every single day of our lives, we undertake some or other research, especially, modern era. Especially the contemporary era. So the first thing you need to consider is, let's take an example. Now the voting is coming up soon, and you have to take a decision about who to vote. The first thing you are going to do is probably go onto Google and Google what are the parties talking about? What does the DA want to do? What does the EFF want to do? What does the ANC want to do? And what does the VF not want to do, for example? Many of you go onto social media sites, and you see a lot of people sort of explaining this happened, or their opinion about something. And that really also presents you a chance to go do a bit of research and make sure that what you are reading is in fact true, and it's not just your friend on Facebook that decided to spew a bit of information today. The most common databases that we use, at least at the University of the Free State, is My LexisNexis or LexisNexis. JuTaLaw used to be known as JuTaStat. We use Safli, HeinOnline, Savinet. I also use a lot of Google and Wikipedia, and I often make use of the librarians here on campus. They are quite useful. With the senior moot, if I'm going to speak about the JSIP specifically, I don't think that LexisNexis or Juta or Safli or Sabinet will necessarily be the best resources for you. The reason being that LexisNexis, Juta, and Sabinet and Safli deal with South African matters, and obviously the JSIP case is not a South African case. So it's going to be a bit difficult to find sources there. But what you will find is that HeinOnline provides excellent sources, and we all have access to HeinOnline. You can also look on Google and Wikipedia. It provides general information. Now, obviously, I need to say this with a bit of a qualification. Don't use Google or Wikipedia as a source or think that you have found your answer. What you'll find is through the process of legal research. In many cases, students come across the first outcome, or they'll search something like S versus Makonyana. They'll go to the first page on Google. They'll find the first source. They'll click on that, and they'll believe whatever opens up and whatever that content is there. And this is a big mistake. I mean, obviously, with Wikipedia is publicly edited, so it has a lot better policy on the kind of information that's there. But Google is not, anyone, even including myself, can go put anything on Google right now, and it doesn't make it a credible source at all. Where Google and Wikipedia help is when you are trying to form a sort of general basis of knowledge on a field. So let's take, for example, the JSIP moot that many of you wanted to participate in now. One of the places where I would start is, what does Wikipedia say about the JSIP moot in general, just so that I know what is the competition about. I want to tell the joke again of when we sent out the call for people to participate, so many students just elected to participate, but they had no idea of what a moot court is or what a JSIP is. And of course, I give that to the students. I think that's an excellent way to just jump into the field like that. But it's also worthwhile to just make sure that the decision you have time for the decision you want to take. What you'll also find is that Wikipedia has nice sort of summaries about international public documents or international public law documents, including many of the Rome statutes, for example, the Vienna Statute. All of those also sit on Wikipedia. So it's a good way to just get a general idea of the field of law that you need to research specifically. Whenever I get stuck, we have excellent librarians here at the university. We have 2 specifically for the law faculty, 3, I believe, now recently. And if I ever get stuck, one of the first things I do is I contact the librarian either through an email, or I'll go see them personally, or I'll just phone them and say, look, this is what I'm working with. I'm struggling to find sources on a specific topic. And then you can let the librarians help you. But again, let me just put in this qualifier. If you go to the librarian and you say, I'm taking part in the 2022 JSIP, it deals with international public law, the librarian is going to tell you to leave. All right. So you need to go to them with specific answers. You need to tell them, I'm looking for sources on section 12 of the International Covenant on Civil and Political Rights, for example. And then they can really assist you to look for sources, decisions, and commentary on section 12 of the International Covenant. But if you don't go there with specific information, you're really wasting their time, and you'll probably be wasting your own time as well. All right, so I have a hypothetical on the screen at the moment. You'll see it's quite long. So what I'm going to do is I'm just going to give 2 or 3 minutes to let you read through the hypothetical. You don't need to read it in depth right now. I just want to use it as an example of the process that we follow once we get a hypothetical set of facts like this. So I'm just going to have a sip of water here and let you read through this hypothetical. All right. So has everyone read through the hypothetical? Can I continue? Another minute you'll have. All right. So I believe everyone should have a general idea of sort of what's happening in this hypothetical. So let's continue. Now you have your set of facts, right? You've read through your set of facts. I would recommend reading through it 2 or 3 times just to get a decent idea. And obviously, start drafting your summary of the facts. But for illustrative purposes, we're going to deal with this set of facts and you're just going to read it once and then we can start going through. Right. So you've read your set of facts. The first thing you are going to do is start with your preliminary analysis. Right? So you read your set of facts. You read it carefully. You read it to try and understand it. And you read it to find all of those relevant facts that are in the fact pattern. Then you're going to start compartmentalizing all of the information that you have gleaned from the set of facts. Right. So you, as I said, with the important or the relevant facts, but you're also going to look at what are the procedural issues and what are the issues of substance in this matter. Remember in the first training, I explained that usually moot courts and most legal disputes have 2 sides to them. All right. Well, they obviously have 2 sides because it's 2 parties, but I mean, there are 2 important areas that you need to consider. The one is procedural area or the procedural issues, and the other one is the substance issues or the merit of the application. Right. So I explained last time that procedure is the method you use to bring a dispute before a tribunal. So one of the big examples is always, does the court have jurisdiction even in many cases? Those are procedural issues. So when you read through the set of facts, you are going to try and find all of the information about what is the procedure followed. In contract law, there's often, certain steps that have to be followed before one of the parties can refer a dispute to court. So you read the set of facts and you try and find out whether that procedure has also been followed. Then with the merit of the application or the substance issues, you're also going to try and find all of the facts that speak directly to, to your client's case. So you're going to look for the relevant facts and you're going to look for the facts that support your client's argument. To give you an example, let's say that we accept that the High Court has jurisdiction in a motor vehicle accident, right? So then the next step is going to be to look at all the substance facts, to look at all the facts of substance and to say, okay, well, look, the other party was driving the car. They were driving the car negligently. Their negligent driving caused a collision. That collision caused damage. So those are the kind of facts you are going to go through. You're going to look for the things that prove your case at the end of the day, not necessarily how you brought the case forward, but also the crux of your matter. Once you contextualize or compartmentalize and contextualize all of those facts, you're going to start to assess yourself, right? So the first question you ask yourself is, what do you know? And the second question you ask yourself is, what do you not know, right? Or what you don't know. So in many cases, for those of you who do find reading interesting, I always recommend looking up what the Dunning-Kruger effect is. And I'm not going to explain more at this point, but it's always safe to assume that once you've read a set of facts that you actually know very little. The more important question is what you don't know, because that is going to direct where your research is going to start, right? So what you know, if you already know everything you need to know about the procedure to be followed for a nation state to bring a dispute before the International Court of Justice, that's fine. Your research is going to be relatively easy there. But more importantly, what you don't know, you'll need to go and find. And it's in finding that research that you start learning these areas of law. right? So then you do what we call research framing. So obviously, there are many types of disputes, and they can go to many different bodies around the world, around the country. So you need to frame your research within a specific context. You need to know what is the jurisdiction. So are we dealing with a South African High Court case here? Are we dealing with an international tribunal? Are we dealing with an international court of justice? Are we dealing with an international arbitration tribunal? Those are important contexts because your research has to be focused on within that context. It is very difficult to find, or it's very difficult to persuade international court, for example, that they should follow national court decisions. Although they can be persuasive, a similar argument would be, should the Supreme Court of Appeal follow, a decision in the small claims court? Now, obviously, we know that is not how the process of hierarchy and stare decisis and precedent works. So we'll need to know from the set of facts, what is the jurisdiction we're studying in? What is the court or the tribunal that we are researching for specifically? And importantly, what area of law are we researching? Because, contract is different to delict, is different to public law, is different to so forth, so forth. And your last step before you actually, turn on your computer and start trying to find the terms is you need to come up with specific research terms, right? So in the process, while you're reading the set of facts, you are going to get an idea of what exactly are the specific research terms. It is really important that these are specific and they need to be very relevant, right? So the more specific, this is how research works. The more specific of an answer you try and find, the easier it is to find that answer. Whereas if you are trying to look for generalized things, let me give you an example. Does capitalism work? Is a very generalized question. So if you start that research, you are going to be led from pillar to post, up and down. But if you ask a specific question, like, does state mandated capitalism that is legislated improve the income of the general population by 5 rand? And there you have a very specific question, right? So there you can go look up. So you are going to have to go research the state's capitalist legislation. You are going to have to go look up the mean income, and you are going to have to draw that mean income over time. It's just one example. But if you are not specific or your research terms are not relevant, it's really going to take you extremely long to try and find the answer. Especially, the nice thing about law is that we have very specific terms that deal with legal issues. So we have stare decisis, for example. We have words like admissible evidence. We have words like, we have definitions, for example, of all of the crimes. So those are going to be important terms. And obviously, just to reiterate, the relevance is it needs to be relevant to the context that you are busy studying. All right, so I have the hypothetical again, and I'm going to sort of show you the process that we go through with all of these things back in mind. So I gave them to you as a step-by-step, but I said it to the candidate attorneys as well. Because of practice, because in my job, I do this every single day, but I've taken part in moot courts and trained moot courts. So I do this very often. So it really comes as a second hand to me these days. And the more you practice this, the more it'll become a second hand to you as well. So we see this set of facts here. The first thing we need to consider is that the learner is 17 years of age, right? So that means we're dealing with a minor specifically. That means that we are dealing with the best interest of the child. That means that the minor cannot institute action on their own behalf, but must be assisted, for example. So do you see how a small piece of information, the age of the applicant, starts to filter into what exactly you're going to start researching? So we know we're dealing with a child here, so we know we're going to be dealing with the best interest of the child, for example. We look at who is the opposing party specifically, right? The who in this case. We see it's the Zulu Heritage Association. Excuse me. So then we go through some of the other information. We see that this is where the main dispute is, right? The requirements for the bursary in this case. is that the applicant must be a female, and B, a virgin, right? So we know that is where the big dispute lies in this case. And obviously the virginity testing is part and parcel of that, right? So then we carry on reading into paragraph 4, and we see that the same requirement is not required for Zulu boys, right? So it seems, the dispute is starting to come up. We have a different legal requirement for females, and we have a different legal requirement for males. And from that, we can see that not only are we dealing with the best interest of the child, but we are also dealing with a form of discrimination, right? So the children must be in their final year of school. I also wanted to point that out, and achieve a 65% average. That is what the boys require. Again, your client says that this differential treatment is unfair. We know that you have instructions to go to the High Court in this case to claim two things. One, that the bursary policy is unconstitutional, and two, to allow your client to apply, right? So now we have seen, okay, we're dealing with a child, so best interest of the child is going to be important, right? We're dealing with a differentiation, So not only are we asking a question of, is virginity testing fair and legal and lawful and so forth, we are dealing with a very specific differentiation between men and females. And we know in South African law, the test we use there is an unfair or fair discrimination test, right? So in South Africa, this is what we know. We know that there's unfair discrimination, and we know that there's fair discrimination. And what are those kind of requirements, right? We know that this matter has to go to the High Court. So we've specifically identified that we are going to the High Court. We know we need to follow the rules of the High Court. And we know that at the end of the day, what we want is, A, to declare the policy unconstitutional, and two, to have our client accepted to the bursary without having to undergo the virginity testing requirement. All right, so here we move into our research plan. I've highlighted some of the key search terms that you are going to bring out, right? I spoke about this. Minor standing, which courts have jurisdiction in constitutional matters, what is fair or what is unfair limitation, or what is unfair or fair discrimination, what is the requirement for the limitation of rights in South Africa, what is the ambit of the right to education, what is the ambit of the right to dignity, right? So these are just sort of some of the search terms that we can elicit from the set of facts, right? We know that these are going to be the sort of areas of law that we are looking at. So I set up myself a sort of table like this that states the date that I started the research, the topic that I'm dealing with specifically, the citation. So a citation is really important because you want to know exactly, you want to have it with you as often as possible. Once you've written it down into the citation list, when you get to the end of drafting your arguments, or even, at some point with memorials, for example, you have to draft a bibliography. For your mini dissertation, you need a bibliography. For your master's, you need a bibliography. For your heads of arguments, you need a list of authority. So this citation category is really to ensure that you have the proper citation from the beginning and you never struggle again to find it. I also have a category for relevance. So relevance, you can decide yourself. I mark it out of 5. 1 being not at all relevant and 5 being extremely relevant. So obviously, your locus classicus cases, your primary law and these kind of matters are going to be 5 relevant. Whereas courts that are, let's take, for example, a Free State High Court decision, and we are in the Supreme Court of Appeal. So we know that the Free State High Court doesn't bind the Supreme Court of Appeal. So therefore, it is not as relevant as a binding decision, but it obviously can still be relevant, especially if there are not many decisions that deal on this part of law specifically. I include a further research category as well. So that's just notes to myself to remind myself, okay, I found this case refers to that case, I need to go and find that case. Or this academic author refers to that academic author, I need to go find that academic article. And so that's the way you sort of build the web of your research. And then lastly, also the location. Location is more of a memory technique, just to let you remember, where exactly in the world it was decided. But it is not so important for these kind of moot courts. It really becomes important when we have private law moot courts, for example, because different countries follow different principles of law. One of the examples that I can just give off the top of my head is that some countries follow a social democrat structure, while other countries follow a monarchy, for example. And the way that those laws are interpreted and applied are completely different. And this is always something you need to keep into consideration is, if we want to use a decision that was taken in America, we need to understand that their legal system works completely different to us. And the same for common law and civil law jurisdictions. So the way laws work in common law jurisdictions like ours, or the European Union in general, London, all of those places, is completely different. It's built on these academic authors, or these authors over time, where civil law jurisdictions build cases, they build their law based on cases. So they have lots of court decisions that basically set out what the reason why the judgment or the legal position is what it is at the moment. So just to give you an example here, the topic could be procedure, and once we have read the sources, we'll see that we'll have to research standing, so locus standi in court, and we'll also have to look up the High Court procedure. How do you bring an application before the High Court? What is required for you to do that? We also know that we are going to deal with discrimination. We can ask ourselves, is it fair or is it unfair? And we're going to go research what is fair discrimination, what is unfair discrimination. We are going to look at the limitations of rights, because obviously we see the right to education, we see the right to dignity. And then we are going to research, what is a justifiable limitation and what is an unjustifiable limitation. And then we're going to look at constitutional rights, obviously, dignity, best interest of the child, and so forth and so forth. And the idea is that we need to know exactly what is the ambit of, for example, the right to education. So the question with this set of facts would be, is the Zulu Heritage Association necessarily denying the right to education, right? Because their job is to give out a bursary at the end of the day. It's not to admit and register students. So we're going to have to go look up what exactly is the ambit of all of these constitutional rights for this specific set of facts. All right, before I move on, I just want to open up the floor if there's any questions or even just comments. I'm going a little bit quick, so even if you want me to slow down or speak about more examples, just indicate it. I see there's a comment here. What about the right to equality? Bandile, do you want to just unmute your mic and explain a bit what you're saying? Bandile?
Sir, the reason I asked about what about the right to equality, because I was looking at section 9, subsection 3 of the Constitution, because it says no person may unfairly discriminate directly or indirectly against anyone on one or more grounds in terms of subsection 3. So,
yes, must be 100% correct. The right to equality would also have to be one of the topics that you're going to research there specifically. And do you see how, now that you know what section of the Constitution it's in, and that it's in the Constitution, you know where exactly to go and find the commentary and the cases on that specific point?
Yes, sir.
All right, good work, Bandile. Ivan, I see you have your hand up.
Good afternoon, Mr. Watson. My question was about how to find commentaries. Besides finding case laws of international courts and stuff, I think I find it a bit difficult to find commentaries on treaties and stuff. So that was my question. Thank you.
Yeah, commentary. Thanks for the question, Ivan. So, for those of you who don't know, I've been training Ivan since he participated in the course first year moot court. So Ivan is one of those examples, excuse me, of someone who came from their first year and has participated in moot courts throughout. So Ivan brings up the point that commentaries are relatively difficult to find, and this is an access issue at the end of the day, a fundamental access issue. When your legal issue, so let's say, for example, you were participating in the Kofsi moot court, that is relatively easy because we know it's going to deal with the South African constitution, we know it's going to deal with South African law, and we know that we have access to constitutional commentary, right? So we can find that in our library quite easily. But when you are dealing with international law in general, so whether that's international private law, international public law, it gets a little bit more difficult. What I can tell you is that there are many, let me not say many, every large international document, if it's the CISG, for example, if it's the International Covenant on Civil and Political Rights, all of those would have a commentary published by a certain publisher or journal or author. The problem that we face often in South Africa is that many of those publishers and authors and journals are not in South Africa. They are outside of the country. So we don't have direct access to all of those commentaries, those sources. What you can often find, the way that I built it up when I took part in international moot courts, is I used Hein Online specifically. So Hein Online often made mention to all of the international treaty commentaries, which then I used to sort of build up my own commentary, my own compendium of commentary. The other way that you can look at is, if you can't find commentary specifically, is to go look at, the Jessup is a good one. The Willem Sievers moot is also quite useful. But you can go find publicly accessible. You can go find all of the Court of Justice's decisions on specific parts of the International Covenant, for example, or, other forms of treaties like the Venice Treaty or the Rome Statute and so forth. So Ivan, I take your point. It is a difficult one, but we're sort of improving it as time goes on. I know for the Jessup specifically that they do allow for, they do make certain material accessible to all of the people to ensure that everyone participates on their own level, on an equal level, sorry. To Shante, I just want to find out with Shante before I give you, Petunia Sele is also, do you have a question as well? Petunia, do you have a question? All right, Shante, can I hand over to you? Thank you, Trishanta. Yeah, I think that's a very valuable point. To build up that sort of matrix. I know, Ivan, what we did back when I still studied, we didn't have access. We were looking for commentary on the International Convention on the Sale of Goods, and we knew there was a commentary because we'd Googled it and we had found that there was a commentary published by 3 or 4 professors. But our library didn't have access to that. So we went to the librarians at the library and we asked them to check at other libraries around the country. So I'm not sure if all of you are aware, but the libraries, university libraries specifically, but libraries in general, form a network, a system. And there are ways and means, mechanisms where you can lend documents and books and commentaries in between libraries. So unfortunately, because commentaries happen to be quite large books, if I can give you a silly example, the commentary on the South African, or let me say the commentary on the South African Constitution is, I'm trying to remember off the top, about 18,000 Rand and 8,000 pages or something like that. So it's obviously, extremely comprehensive. But what we did then is we approached the library by us, and we asked them to check at the University of Pretoria, for example, if they had the specific commentary. And it turns out that they did. The University of Pretoria, had the money to afford the subscription to that library. So, that's the other thing you also need to keep into consideration. The university pays for these subscriptions in dollars, for example. So if a subscription costs $20,000, the university is not likely to pay that if we're only going to use it for one moot court every now and then. But other universities do. And then University of Pretoria's library was able to scan the relevant pages to us, and scan and then send the relevant pages to us. And that was one way we got access to some of the documents. All right. Any other questions before I continue? Yeah, when I hear the silence, I miss a class, because in a class I could have pointed to someone. And now, I'm unsure if any of you are just sitting there in your pajamas with a nice cup of coffee and a cup of popcorn and not even listening to me. But that's all right. Let me continue, yeah. All right, so we saw, these are some of the research terms that we just picked out from our set of facts specifically, right? So your next step is then to start identifying sources. So we know all of the facts at this point. We know where we've contextualized our research, so we know where exactly we are looking for sources, and we know exactly what we don't know, and we know exactly what we want to know. So obviously there are 2 forms of sources in South Africa, in law in general. We have primary sources and secondary sources. In the South African context, in our law specifically, our primary sources of law usually come from our constitution, legislation, regulation, or case law, for example. Whereas our secondary law comes from academic textbooks, scholarly articles, dictionaries, commentary, and law review articles. So in international moot courts, for example, it'll follow a very similar line. But instead of a constitution, you would obviously have a covenant, for example. That would be your primary source, right? Your legislation could also be forms of legislation that was enacted specifically to give effect to that covenant. Your case law is your decisions by your UN bodies, for example. But remember, just to hang on to the question about commentary, commentary is a secondary source at the end of the day. And although commentary is persuasive, it is not completely binding. And the best thing about commentary is to find it just contains many of the sources that you need at the end of the day. So primary sources are an authority that comes directly from a lawmaking body and are authoritative in argument, right? So if we have a piece of law that says you may not, let's take the regulations that we have currently in front of us. So we have the Disaster Management Act and we have the regulations. And those regulations say that you may not be outside of your house without a good excuse after 10 o'clock in the evening, right? So your Disaster Management Act would be your primary source. Your regulation would be your primary source, and that is an authoritative argument in a court of law. You know, it's very sort of simply set out. If you get arrested because you took your dog for a walk at 2 o'clock in the morning, you know, this is going to be the question in front of the court is, what does the primary authority say about this specific conduct? Again, I've given you, you know, constitution, statutes, regulations, case law, and law reviews. Those would be most of your primary sources. Remember with case law is a primary source if it's binding, sorry. So constitutional court is obviously a primary source. Supreme Court of Appeal is a primary source unless there's a constitutional court case. High courts are a primary source if it's in the same jurisdiction, unless there's a Supreme Court or constitutional case, for example. So remember, again, your binding authority and the principle of stare decisis, what decisions bind the decision in the court in front of you, and how do you build up that precedent to get to the legal position or to the legal outcome that you are specifically looking for. Secondary sources, on the other hand, are often useful because they help explain the legal principles more thoroughly than a single case or statute. So you often use them to bolster your argument and also save you a bit of time in your research, because obviously they'll refer to all of the court decisions or to all of the primary sources that you want to use. So secondary sources are very useful when you're trying to learn the basics of a particular area of law, or you don't understand a specific term, like Deshante said, asylum is one of them. If you don't understand a specific term like asylum, you can use secondary sources. And it also helps you to identify essential cases and statutes. So, and you know, there's a good reason for this. Commentary is often written by academic authors, you know, and academic authors' opinions are not binding in any effect, regardless of what your lecturers, you know, have tried to teach you over the last 4 or 5 years. In a court of law, an academic's opinion is definitely useful. It's definitely if you're dealing with the same set of facts. But the difference is fundamentally that academics can be hypothetical, whereas, you know, if you are going to participate in a moot court or you're going to become a legal practitioner one day, you only have the set of facts that's in front of you. You know, you can't change your client's statement. You can't change what has happened in the past. So these secondary sources are really useful in that kind of way. So when you are using secondary sources, one of the issues that comes up with secondary sources is there are many of them, and you need to ensure that you are using credible secondary sources. So one of the ways you do this is you always keep 3 considerations in your head. The scope and the breadth of the commentary or the secondary source, the depth of treatment of the specific issue, so how in depth do they discuss the specific issue, and whether it's current or in any regard reliable, right? So let's go to the previous, let's say we're dealing with the set of facts the hypothetical set of facts that I gave you earlier. If we came across a secondary source that was just generally dealing with, discrimination in the workplace, for example, that does not deal with all of the essential characteristics of our set of facts, as much as if we found something that dealt with virginity testing for a bursary specifically. Right? So if we found an academic article on the constitutionality of virginity testing as a bursary requirement, that's quite nice because the scope and the breadth of the article really deal with the issues you're looking at. And obviously academics do have to deal with complex issues, and they have to deal with these kind of issues in depth. So they need to consider and speak about every single possible avenue or opinion or side of the story. Excuse me, I'm just coughing. All right, and lastly, you also need to consider, how current and how reliable is your secondary source. So someone gave me a really funny example of this one day. But they said, if, let's take, we all know Prof. Mubangizi, for example. So if Prof. Mubangizi wrote an article in 2019 dealing with virginity testing, that's quite nice because it is extremely current and it's reliable because his position as a dean of a faculty, for example. But if Mang Mang writes about, writes it in a Facebook post, then you need to consider, is this article in front of me on Facebook, does it really deal with the entire issue? Does it deal with all of the issues? And is it reliable and is it current, for example? All right, so then I just wanted to give you a sort of quick explanation of how to use the university's electronic library. So you'll see you go to the university's website, you click on the library tab that I've highlighted there. You'll open up on this library page, you go to resources, and you'll see just under resources tab is electronic resources. You click on that tab, and then you'll come to the A to Z database list. So as a quick tip, I have this A to Z database constantly bookmarked, right? So I just have to click on the bookmark and then it'll take me straight to the A to Z database of the database list. Then you need to select the first letter of the journal, right? So, there are examples. LexisNexis, for example, will be under L and M for my LexisNexis. Tutor will be under J, obviously. Hein Online will be under H. I don't have to sort of explain these things to you. What you'll also see is that you can search the databases. So you can search for specific subjects, specific database types, what type of vendors or providers are they, and this will help you to find journals that deal specifically with the area of law that you want to deal with. All right, so now you've gotten to the point where you have found and read through thousands of sources, and you know exactly, you have gone through all of the databases, you've gone into every single journal, you've read the sources, you've read the court cases, and now you have this huge sort of file in front of you that you need to start drafting legal arguments from. So your first step is going to obviously to be evaluate each and every single one of the sources that you have obtained. You need to figure out, is the source completely for me or is it against me? And this sounds simple, but don't make the mistake of just reading the head notes. I've been in the situation before where someone tried to use a court case, but they didn't read the entire court case. And there was a specific paragraph in the court case that said, if it was not for A, B, C, I wouldn't have found for the applicant. And it so happened that the moot court set of facts that we were dealing with, A, B, and C, did happen. So it was very easy to turn that one around. So you need to look for what are the cases, what are the sources that support your argument, and importantly, what are the cases and sources that they're going to use against you, because obviously you're going to come against an opponent who is going to want to use these sources. So it's good to start thinking about how are you going to make sure, how you're going to persuade a court to prefer your sources over your opponent's sources. You're also going to sort them into the strongest and the most relevant primary and secondary sources, right? So you want your strongest sources and your most relevant sources right at the top. They are going to be the most persuasive in a court of law. There's a big difference between, having a constitution that says, Bandile, for example, read section 9 there to us, no one is allowed to face discrimination, for example. So that constitution is a strong and a relevant source. It is obviously going to be right at the top of your list. Whereas if you find a newspaper article, for example, that says discrimination, there's no such thing as fair discrimination, and that's not going to be as strong a source, and it's not going to be as relevant of a source as well. You're going to look at, is the source national or international? So that's going to speak to the jurisdiction and the binding nature of the source. And from that, you should be ready to start drafting your legal arguments. All right. So now you have your sources, and from your legal sources, you are going to build, and you're going to use that as a foundation to start drafting and growing all of your legal arguments. The next slide I have is just about general tips and tricks. Again, before I move over to the general tips and tricks, do we have any questions or any comments at this point? If no one has any questions, or everyone is up to date and with me as we continue. All right, then I will take it. So general tips and tricks. Tell me, raise your hand if you've ever heard of a Boolean search. Has anyone who's part of this training heard of what a Boolean search is before, or ever used a Boolean search? Okay, so on a basic level, a Boolean search is it's things you add to your search so that you can find more specific results, right? So there are 4 elements that you need to understand to this one. The first one is that when you, for example, put in Google, or you're searching a specific journal or a database, if you put the word "and" in between 2 of your search terms, you are only going to get research where both terms appear, right? So if you search South African Constitution and equality, you are only going to get resources and sources that mention both the South African Constitution and the right to equality. But if you type in a search and you put in "or" in between your 2 research terms, you are going to get all research containing either of them, right? So you're going to, even if an article only mentions the South African Constitution, but it doesn't mention the right to equality, it is still going to appear, for example. So do you see how, just the difference between adding an "and" adding an "or" in between your search term significantly changes the amount of results you get, and that in turn obviously makes it easier or more difficult to get specific and relevant resources. Right? You can also use the word "not" to exclude certain research topics or certain topics. This is useful when there's a specific term you want to research, but that the term appears in lots of different parts of law, right? So it's difficult to come up with examples off the top of my head, but the big ones that usually happen is when there's a popular band, for example, that has the same name as, the term you are looking for. So to use Tosante's example, sometimes it can happen that there's a band that's called, or a singer or a rapper or something, or a Facebook personality, his name is Asylum. And now every time you try and Google Asylum, guess what pops up first is, the singer or band or whatever. So then what you would do in those kind of situations is you could type in Asylum, not band, for example. So that would exclude any of the research results that deal with Asylum referring to the band and not the legal principle. And then you have the semicolons. The semicolons is by far, the apostrophes. The apostrophes are by far my favorite search extract to use. What happens is that if you put in Google, let's say Google specifically, if you put in a specific search term and you put it in those apostrophes, Google will search for websites that contain that exact term, right? So it would be the exact same with journals, for example. If you were searching various sources on a journal, if you put in your search term in those apostrophes, what you'll get is you'll get results that look for that exact terminology, and this is extremely useful. So Bandile, for example, mentioned section 9.2 or section 9.1 of the Constitution. So if you put in South African Constitution and then in apostrophes, you search section 9.1, all the results that you will get will contain section 9.1, that specific phrase. All right. Google search terms also has a good way to go along these things. I don't know if any of you have ever used the specific site search on Google. Not before. All right. I want to give you a quick sort of example that we are dealing with here. So let's take the Jessup set of facts. I'm going to assume that at this point you have all read the Jessup set of facts, right? So we know at one point we're going to deal with is certain evidence admissible, right? So now we know that we're going to deal with admissible evidence, and we are going to deal with, for example, let's think of another one, admissible evidence and the International Court of Justice, for example. And so we'll see here we have 27 million results. Now, obviously, reading through 27 million results is going to take you absolutely forever, right? So what we do now is we'll put admissible evidence in apostrophes, for example, and then we'll see suddenly we only have 3 million results. Right? So there's a massive difference. The admissibility, then we can start looking through all of these different options. And so this is an extremely useful one. Let's use the hypothetical set of facts that we have, right? So we know we are dealing with unfair discrimination. So if we just search unfair discrimination, we're going to get 46 million results. So now we look up unfair discrimination and we want to look at, what does the Supreme Court, for example, say about unfair discrimination? And we are still going to struggle here. Now we have, 9.5 million results, but we do see some here. So now what we can do is try to be very specific, right? So we are going to type in site, safli.org, and we are going to look up unfair discrimination. And what we have now is we have 5,000 results, all specifically from the Safli site that deal with the words unfair discrimination, right? So they'll have legislation there, for example, and then we'll start going through all of the court cases. And you can see from the dates on these court cases that they are relatively new, right? And we know exactly, we are searching Safli. Safli contains all the South African court decisions. And these would be all of the court decisions that specifically contain the words unfair discrimination. And just to give you an example of how to use the not function, so what you can do, let's say it's unfair discrimination, but we are not dealing with employment, for example. So you would just type in a minus sign and then labor. And then what you'll see is now we have 2,000 results almost that deals with unfair discrimination, but that doesn't include a labor context, right? You all understand how exactly that works. This is really something you'll have to go and practice over and over and over again. Because as you get better, obviously it learns from you and you learn how to do it a lot quicker. So the last slide that I have is just your research checklist at the end of the day. So have you read and understood the facts? Do you know who the parties are? What is the legal issue? What is the relevant facts? And what is the applicable law? You need to ask yourself, do you know what your key search terms are? And do you have a research plan? You need to ask yourself, have you found enough relevant sources? Obviously, 20 sources is too much, but one source may not be enough. It really depends on what exactly the kind of legal issue you're dealing with. You need to make sure that all your sources are valid, they're binding, they're authoritative, they haven't been repealed, and they haven't been amended yet. And you need to ensure that you keep a proper record of all of the research that you do, because I promise you, out of everything that I've given you today, remember to keep a record of your research, because nothing is worse than being up late at night trying to finish off your research or to finish off your arguments. And all you need to do is reference a specific source, and you just can't find that source. So then and then you're not on campus, so you don't have access to the libraries, so forth. I mean, it is a nightmare. But that concludes my presentation. I think we have a few more minutes for questions. or any clarity or anything else that anyone would like to ask. I see there's a question here. How do you identify if a case has been criticized or not? So it depends. There are one or two ways. Let me show you. Sorry, I'm just logging into LexisNexis, and then I can show you how exactly to deal with whether cases have been criticized, applied, appealed, viewed. I just want to open it up. Just taking a while to open up. I see there's another question. Is it a good thing to add my own opinion when writing a case summary? What do you mean? A case summary just in general, or are you asking about a specific case summary? In general. So no, you would never put your own opinion in the case summary because obviously your opinion is not part of the facts. A case summary is there just purely to objectively state what exactly happened in this case. Sorry, as many of you know, LexisNexis takes extremely long to open up. So yeah, I'm on LexisNexis. I truly hope that this is not the first time that many of you have seen LexisNexis specifically. So let's take a case that we can think. All right, so I may have spelled it wrong. But yes, for example, we have a court case to prove as Minister of Justice and Constitutional Development. So LexisNexis has what we call a citator, a legal citator function. Unfortunately, we don't have a legal citator for international cases yet. But what you'll see here is just on the other side, we have the LexisNexis legal citator. So this will speak about all of the important parts of the case, who the judge is, what court it was in, when it was in the court, and so forth. But importantly, it also gives you a judgment treatment. So LexisNexis is by far the most comprehensive legal citator that you can possibly find. Right, so here we look at the judgment, we go to the judgment treatment, and then you can see it was the Constitutional Court referred it in South African Police Services for solidarity. the Western Cape High Court considered this decision in the South African Restructuring Insolvency Practitioners Association with the Minister of Justice. Then you can also see you have it distinguished. So they have these little marks. What you'll see is that a neutral refer is always just a little blue like that, whereas distinguished is a matter where the same set of facts apply, but there is something that justifies going away from the normal legal position, or the accepted legal position. Often in criminal cases will be the biggest example of where you need to give caution to the judgments that you use, because we can't say that a minimum life sentence is necessary for murder because we found a case about it when we know that the personal circumstances will be applied when coming to a sentencing decision. And those personal circumstances would be the ones where a case is distinguished from another case. Applied is perfect. So the little blue button or the little green tick means that it's been applied properly, right? The Equality Court in this case applied the decision into previous the Minister of Justice and Constitutional Development back in 2013. And then there's no options here, or there's nothing here, but you'll see this little red means that it's been rejected. So there, if you find a case that has a constitutional court case or a Supreme Court case that has rejected the legal position, then you know that this case has been appealed or has been overturned, or there's a new decision that changes the legal position. All right. I see there are a few hands. Ivan, yours is the first one that I can see. I can't hear. It appears on hold on my screen, and I see there's a hand in one of the participants, but I can't see where it comes from. Does anyone else? Let's give Ivan a minute. Does anyone else have a question while we wait?
Can you hear me now?
Got you. Go ahead, Ivan.
What I was saying is that there are sites that I know where you can find international cases, which are, the websites of the court itself. When you go to, take for example, when you go to the European Human Rights Court, when you search for a case, you'll find it there. Or when you search keywords of the case, you'll find cases that deal with what you've searched. And again, there is a website called JSTOR. I don't know if I pronounce it properly, JSTOR, where you can find academic articles for the website itself. It's almost like deals with international law in essence. I think that's one platform that one can find academic articles, like what Toshante said, that academic articles usually cite cases and stuff, and then you can get cases from those academic articles. And my question was, I just wanted to mention that for the assistance of my learned friends here. My question was, is a judgment of a continental court has authority when it comes to international International Court of Justice? Does it have authority? Because it's looking at the hierarchy, because it's an international court. One would think that continental court are bound in essence by decisions of the International Court of Justice. Yeah, that was my question.
All right, thanks, Ivan. Yeah, you have a good point with Justo. It's pronounced Justo. Justo is a good database that the university has access to. It's a really good place to find those kind of judgments. In short, Ivan, continental courts don't bind the international court. When you think about international law, you need to think of it completely differently to the context in South Africa, where we have a direct vertical hierarchy, a linear hierarchy of courts. So we have one line that goes straight up from the bottom to the top. But that is not how it works in most international law subjects. So, for example, you can have the Inter-American Court of Justice, you can have the African Court of Justice, you can have the Southern American Court of Justice. But those are completely separate bodies to the ICC, for example, or the ICJ. Similar with states in America. Right. I see Zoleka has a question with regards to international cases, because Safety Tutor and LexisNexis don't have them. Where can we get them? I think Ivan answered that question. Are there any other questions before we wrap up today? Or have we at least answered all of the questions that were posed? All right, it seems that we have answered all of the questions. Deshante, I'm going to hand over to you to do the closing.